as you listen to the two different versions, the dun 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 dun, the only difference with Vanilla Ice's is he says dun 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 dun. Like he adds a little sound at the end of it, but it's so clearly pulled from Under Pressure. This is Ask a Lawyer with Blaine Cluton. I usually start the top of these shows by saying, I am an attorney, but I'm not your attorney. Today, we are going to be talking about copyrights. This is part 2 of our discussion. And if you have questions at the end of this session, I would encourage you to talk to an attorney. This is a good starting point, but it should be by no means your end point. We are lucky enough to have Professor Eric Priest joining us in studio again. Professor, can you hear me okay?
I sure can.
Awesome. Well, thank you again for joining us on this session. The last session has already been released on trademarks, and I can report to you, you don't have this data, but I can tell you that I've been able to review downloads, and this has some of the highest downloads for the first 7 days of any podcast that we've ever done. So we're getting a really good reception on the trademarks session that we did previously. So I'm excited to have you back on for Copyrights Part 2.
Great. Well, it's my pleasure. Hopefully it sounds like some people find it useful. So that's what I'm here for.
And Professor Priest is a professor of law at the University of Oregon School of Law. And he specializes or teaches first-year property, teaches copyrights, trademarks class, and then an intellectual property upper division class. Is that right, Professor?
That's right.
And if you need more of his CV history, please listen to that first trademarks episode. We go through a nice history of his background. So as a preface to what we're going to be talking about today, Professor, we've talked about copyrights in another episode that hasn't yet been released. This is a follow-on to that episode, and the questions that we're going to be talking about are, can you sue someone for posting a photo of you? Can you sue someone for posting a photo without your consent? Can I sue someone for using my photo? Can someone take a photo without your permission? What is protected when I record a song? And so this is perhaps musical work versus a sound recording. Do I need to register my recording? Can I use a snippet of someone's song on my blog? And can I cover someone else's music? Play it like a cover band. So taking this from the top, since we got a good preface of copyrights in general in the last episode, I'm hoping that we can jump right into the question about, can you sue someone for posting a photo of you, Professor?
Yeah, so that's an interesting question. If we're talking about suing someone from the copyright law perspective, the answer is going to depend on whether you are the owner of the photo. So whether or not you are the subject of the photo, that's not the key question, frankly, from a copyright perspective. It's whether you are the owner. And typically that means you're the author. You're the one who took the photo. So when we say, can you sue someone for posting a photo of you? The first question I would ask as a copyright lawyer is, who took the photo? Is it a photo of you, like a selfie that someone else is posting? Or is it a photo that they took? And in particular, a photo that they took with your permission. Now, that is not necessarily crucial for copyright purposes, whether or not you gave them your permission, but you may have another cause of action against someone, although it's frankly probably pretty unlikely, but you may have another cause of action against someone for taking your photo, under privacy laws or right of publicity, some other area. But from a copyright perspective, what we're really interested in is whether or not you have a property right in the photo. And that typically derives from you being the author of the photo. And in copyright law, we call everyone who's a creator an author. We don't normally think of a photographer, for example, in lay terms as an author. But when I use the term author, I'm using it as a copyright lawyer. And that means that you are the individual that authored or created the expressive work that's the subject of copyright.
Okay, and you raised a good point, because we are just talking about copyrights. And of course, you're not foreclosed from any other area of the law. There's still potential torts that could be available for invasion of privacy or some other right. But purely from a copyright perspective, let's just assume for purposes of the hypothetical that someone else has taken a picture of you and now they've posted it online without your consent. And that person is the author. Let's just say that they use their phone to take a picture of you. And does it make a difference, I guess, if it was with your knowledge or without your knowledge, with your consent, without your consent, for whether they're allowed to post it or not?
Not really if we are talking about from a copyright perspective. I mean, that can make a difference in terms of, whether you're an author, you might be a co-author, right? So, in fact, there's a famous case involving a photo of Kevin Garnett and, sort of standing for the proposition that, people who are involved in kind of setting the scene of the photo, and that could be the subject of the photo as well, but it could be the photographer. It might be both. But the idea is, if you are involved in sort of creatively masterminding the photo, you might be an author, and then you could use your property rights potentially to ensure that the photo isn't posted without your consent. But you're going to run into a problem if somebody else took a photo of you and they're considered at least a co-author and maybe the sole author of the photo. They're going to have the property rights in that photo, and there isn't going to be much that you can do about that, which is something I think that surprises people quite a bit, to imagine that a photo taken of you may be something that you have no ownership interest in. But copyright law really focuses on the author of the works and determining who the author is, and the rights kind of spring from that determination. So merely being the subject of a photo isn't really typically going to give you rights in the photo unless you are also an author. So you could be a co-author of the photo, but if you're not an author of the photo, then there isn't going to be much under copyright law that you can do about the posting of the photo.
Now, at what point does the question of commercial use come in? And the hypothetical that I'm thinking of is, let's say that the author, the person that's taking the picture, takes a picture of someone that is well known or somewhat famous, and then they post it. Now, I guess the hypothetical can go in two different directions. In one case, they're posting it to promote a business. They're just associating this famous person that they've taken a picture of with this brand or this business or something like that. I guess in the second hypothetical, they're just taking a picture of a famous person and posting it to their blog or their website or something like that. Does copyright law care about commercial purpose or what the intent behind the picture is and why it was posted?
Well, again, not really, unless you get into questions of fair use. Then you might consider the commercial effect. But that's usually in the context of where, that would come up in the context of where you're essentially using somebody else's work as part of your own. So here what you're talking about is if somebody took a photograph, let's say they take a photograph of a celebrity and they post it for commercial reasons, sort of to gain attention on their website or use it as part of their business advertising, something like that. That's generally not going to raise a copyright problem because, again, we would look to who's the author of the work. And if the work is the photograph, that's typically going to be the photographer, as I said, unless the subject was involved in staging the photograph along with the photographer. So that's where you would look to other areas of the law. And especially if you're talking about a celebrity, then you'd be looking at right of publicity, which is another kind of intellectual property right that's different from copyright. And that's where you would go. In fact, the right of publicity developed because, among other things, there wasn't a right under copyright for individuals whose likeness was misappropriated by another for commercial use. So that's really kind of a special right that's recognized in order to address that problem. Yeah, so copyright would not typically be the right body of law to look to for redress in that situation.
Okay. Now, are you able to talk about right of publicity at all? I kind of want to keep going down this track just a little bit, if that's okay.
Sure. I don't consider myself an expert in right of publicity, but I could certainly talk about it.
Okay. Are there any key cases that come to mind that you've read about before on the right of publicity where either this is developed out of where someone has used somebody's likeness without their permission? Does anything like that come to your mind?
Oh, yeah. And of course, there are many of these kinds of cases. So one case that I actually teach about that is very well known in the right of publicity area is actually a case involving Vanna White. And it involved actually an advertisement by Samsung back in, I think, the late 80s that utilized kind of a C3PO-like robotic figure in the ad with a blonde wig on and a dress, and was standing in front of the Wheel of Fortune letters. And so it was kind of a parody of Vanna White, right? And she has such a distinctive profession, right? Such a distinctive job. All she does is stand in front of this, board of illuminated letters and turn them. And she's about the only person in the world who has that profession. And so it's immediately recognizable. And her argument was they are commercially benefiting from using my likeness. Now, you might say, well, they're not using a photograph. They're not using her name. They are, at most, kind of calling to mind, and in a humorous way, no doubt, Vanna White in really her occupation. But her persona was, her public persona is kind of bound up in her occupation, right? But she was ultimately successful. Now, right of publicity is a state law cause of action, but states like California and New York that have a lot of show business, it's a major part of their economies. Those are jurisdictions where you see a lot of right of publicity cases. And so in this case, it was California, and under California law, that was found to be a violation of her right of publicity.
And that's really interesting as I'm hearing you talk about this, because if that example is a violation of the right of publicity, or I guess another way to phrase that is she had a cause of action for their using of her likeness. You can imagine then that the other cases where somebody's taking a picture without the famous person's consent, that's just a clear-cut case, and it's going to be a very obvious win. So that's probably why it doesn't happen very frequently.
Yeah, right. I mean, exactly. If you take a picture of Kim Kardashian at an event, that's probably not a violation of her right of privacy, because she wouldn't have a reasonable expectation of privacy. And again, I'm not a privacy law expert, but if she's at a public event and you take a photograph of her, that is very unlikely to be a problem from a right of privacy perspective, because she doesn't have a reasonable expectation of privacy in that kind of scenario. So taking the photograph shouldn't be a problem, and commercializing that photograph shouldn't be a problem in a sort of typical expressive sense. And what I mean by that is, let's say you're paparazzi, right? And you take that photograph. And again, to kind of keep the privacy issues, set those aside, we'll say it's at a public event where she doesn't have a reasonable expectation of privacy. This isn't in, her backyard, right? In that case, there generally wouldn't be a problem with commercializing that photograph, as I said, in a kind of a typical expressive sense. You use it in your tabloid, you use it, as part of a news article. You haven't violated any rights of a celebrity in that scenario. But when you use it in a sense that suggests that the celebrity endorses or is associated with your business, as opposed to saying, here's a photograph of this celebrity. That's different from using the photograph to intimate that the celebrity somehow endorses or is associated with your business, if that makes sense.
Yes, it does. I imagine that the close call, although this probably doesn't come up very much, is where these pictures are taken in public like you're describing, and they're put in Us Weekly or some other tabloid, for example. And let's just say that it was a half page of a photo, and then the bottom half of the page was a eyeliner. And now you've just taken this picture, and maybe there's a headline or something that says something like, caught off guard with no makeup, and then below that there's an ad for makeup. I don't imagine that the tabloid would put something that close, because in that sense you're running the risk of making it look like there's some sort of endorsement there or some affiliation. Mm-hmm. And that's probably why these tabloids, when they're doing these pictures, they're full page spreads and the advertisements are on completely different pages.
Yeah, no, I think that's right. And so, really, really understanding the distinction between an expressive use, right, of an image of a celebrity and a kind of commercial use that suggests that you're using their identity in association with your goods or services, as opposed to merely saying, here is an expressive work that shows, this individual. Using their image in an expressive sense is typically not going to be problematic from the perspective of right of publicity, whereas essentially attempting to commercialize their identity and associate it with your going concern, your business, that's going to be more problematic.
Okay, well, the last 10 minutes or so, I wanted to talk about something near and dear to your heart, which is music. I'd like to first talk about what is protected when I record a song, so the difference between a musical work and a sound recording, and then questions from a copyright perspective about registering a recording, using snippet of somebody else's song, and then covering other people's music. Would you please just briefly define what is protected when I record a song?
Sure. So when you record a song, there are really going to be two works involved. One of them is the song itself, the underlying musical composition, and the other is the recording that embodies that underlying musical composition. Now, sometimes some of my students, confuse these or find this to be a difficult distinction. What I say is think about, for example, even though this example dates me compared to some of my students, I think it's Yesterday by Lennon and McCartney, which is the most covered song in history, right? So Yesterday, I think it's been recorded, 1,000 times or something and commercially released. So each one of those recordings is a distinct copyrightable work. Why? Because each one of those resulted from a separate creative endeavor, right? Mm-hmm. And those recordings, if you listen to those recordings of Yesterday, every one of them is going to sound distinct and unique in its own way, right? Because it results from a unique creative endeavor. But the song Yesterday will be the same throughout. Now, of course, the arrangements will be different, the performances will be different, but the underlying song is the same, right? And so that is subject to its own distinct copyright, apart from any recording in which a performance of the song is captured, right? Understanding copyright in music, it all stems from this basic distinction between the copyright in a musical work and the copyright in a recording of the musical work. And those are two separate copyrights.
If Yesterday is covered by somebody, do those estates or those people that originally recorded and own the song itself, do they get a credit or some sort of royalty on the sound recording? Or how does that part work?
Yes, they do. That will come up in different ways. And I say that because there are different rights involved in the use of a song, right? So if you think about, if you, Blaine, make a recording of the song Yesterday, you are reproducing that musical work in a mechanical form, right? You're reproducing it not as words on a page, but when we say in mechanical form, it's basically in the form of a recording, where the sounds can be reproduced mechanically.
Right.
Today, obviously, by your phone or, your laptop, whatever you use to consume music now. So that reproduction that you make implicates the reproduction right of the underlying musical work copyright owner. Another reproduction that might be implicated is if you buy sheet music of the song Yesterday, right? That's the most classic form of reproduction of a musical work, right? For hundreds of years, that's the kind of reproduction of musical works prior to, sound recordings that people thought of when they thought of the reproduction right in association with music. It wasn't until the early 20th century when people started recognizing that there's another new form of reproduction, which is that reproduction of fixed sounds that make up a recording of the musical work.
So if I cover Yesterday and I master it, I release it on Apple or Spotify or something like that, and people start listening to it, do I then have to pay royalties on that, or how does that portion of it work?
Yeah. So I talked about the reproduction right. There's also a performance right. And that's also implicated when somebody covers your work because, again, under copyright actually consists of 6 different rights. And those include the right to reproduce and the right to perform. So when you do a cover version of the song Yesterday, not only are you reproducing it, and you as the producer of that recording will owe a royalty to the copyright owner for producing that recording, for reproducing the musical work in your recording. But also, when that recording is performed, let's say Blaine turns Yesterday into a smash hit and it's played on the radio, it's streamed 100 million times on Spotify. Those are all considered performances, the work, because we think of a broadcast, whether it's, via streaming or over the air, terrestrial broadcast. We think of that as a performance. And that is a completely different right, the performance right, and therefore subject to a different royalty. And there's a whole different payment mechanism set up in the music industry to collect on behalf of songwriters and music publishers who represent songwriters those public performance rights. Yeah, so if you record Yesterday and you commercially distribute that recording, you're going to owe a royalty for what's called a mechanical royalty to the owner of the musical composition, so Lennon and McCartney and their publishers, for that reproduction right. And also, you will pay a royalty also to their music publishers for the reproduction right. No, I'm sorry, for the performance right for performing their work. Now, in fact, you typically won't pay that. And so I think this gets to your question about how does this actually work? You do actually owe for the reproduction because you're the one doing the reproduction. You owe that royalty to the owner of the underlying musical composition copyright. But the way you do that, because you might say, well, do I need to go to them and get their permission? In theory, you typically would, but under U.S. law, you actually have what's called a compulsory license when you make a recording based on a work that's already been published in the U.S., an underlying musical composition. Then you can actually just get an automatic license. That's what a compulsory license is. The copyright owner can't say no so long as you pay them and meet certain statutory requirements. Most people don't even deal with that. What most people do, so really in the real world, if Blaine wants to record Yesterday, you're just going to go to an agency called the Harry Fox Agency, and they handle these licenses, and they would just say, okay, yep, you can record Yesterday. Here's what you're going to pay us per CD sold. Here's what you're going to pay us per stream. And in fact, typically that will be paid out by the streaming service, not by you. And that's how it will work. That's how you would get the license. But if you don't do that, if you don't get a license from Harry Fox and you don't take care of the statutory requirements, in the alternative and get a compulsory license, then you'll be violating their copyright. So you can't just record somebody's work without either getting that compulsory license or working through the Harry Fox Agency. And then for the performance right, you probably heard of ASCAP and BMI. These are called performance rights organizations, and they represent songwriters and music publishers for that underlying musical work, and they collect performance royalties for all of their members. In fact, there are 4 organizations: ASCAP, BMI, CSAC, and a new one called GMR. And so that's how the songwriters get paid for the performance over the air or over streaming of their work. That right, by the way, would not be implicated for like a digital download or if you buy a CD, because there's no public performance of the work in those cases.
I have 2 more questions and then one last example I want to talk about. It's one of my favorite copyright examples. But before we get to that example, let's say that I have an original song that I've recorded. Do I need to register my recording?
Well, you don't have to register your copyright in order to acquire rights in it. So copyright in the United States attaches automatically so long as you meet the threshold requirements that we talked about, I think, in the last podcast for copyrightability, which are it's an original work of authorship fixed in a tangible medium of expression. So you don't have to register it, but there are benefits, significant benefits to registration. So one of those is you won't be able to enforce your copyright in court unless you register it. So you have to have a registration. It's kind of your ticket to the courthouse.
And then the other question I wanted to get to was, can I use a snippet of someone's song on my blog or on my website?
So, or like in a podcast, for example.
Sure.
So that would really depend on the context. If you don't have a license or you don't have permission to use the song, then you would essentially be technically infringing unless you have a defense like fair use, or what's called a de minimis use defense, if maybe you're using a very, very trivial small portion of the song. But you're sort of stuck at that point in a position where you are having to backfill and raise an affirmative defense to infringement, which is not a great place to be. So if you plan to use music, I would strongly recommend you either get licensed music, and there's tons of licensed music available now, or music that's easily licensed, kind of stock music, or, if there's a particular song, probably need to clear that. You need to, reach out to the publisher or through a clearinghouse to get the rights to it. Otherwise, it's playing with fire.
Well, it's a good thing you answered that first, because I wanted to include my next example as a snippet, but maybe I won't now.
Well, there may be a strong fair use argument for doing that because, you're educating the public, and if it's a snippet of audio, that would be a pretty strong case for fair use.
Well, let's talk about this last one. It was when Vanilla Ice sampled from David Bowie and Freddie Mercury in 1991, Ice Ice Baby, but he did not credit David Bowie or Freddie Mercury, and he did not clear or license the sample beforehand. I think ultimately this case settled out of court. I don't think it ended up going to court. But as you listen to the two different versions, the dun 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 dun, the only difference with Vanilla Ice's is he says dun 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 dun. Mm-hmm. Like he adds a little sound at the end of it, but it's so clearly similar that I don't know how else you could come to a conclusion that it wasn't pulled from under pressure.
Yes.
But I think that's one we talked about in class.
Yeah, we probably did. That was in the Wild West days of sampling. There's very little that could be raised in defense of that use. That's using somebody else's recording and very likely their composition, unless you think that, those two bass notes, dun, 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 right? I mean, unless you think that's a de minimis use. And it could be. There was a Beastie Boys case involving the Beastie Boys and James Newton, the jazz flautist, that held that their use in the song Pass the Mic of 3 flute notes that he plays was de minimis for the underlying musical composition. But you have to understand that, again, there's the underlying musical composition, but also the recording. They had a license to use the recording. If you didn't have a license to use the recording, it would be very hard to claim that that was a de minimis use, whatever it is, 6 seconds of a recording. And in fact, one case in the Sixth Circuit held that any use of a recording, no matter how short, is infringing. Now, you could maybe raise a fair use defense, but you're certainly playing with fire if you're taking both the underlying musical composition and the recording, right? Which is what you're typically using with a sample. And if you're using those without permission, that's going to be problematic usually.
So I love the Beastie Boys example. I'm thinking of the Kanye West song Gold Digger. I think he ended up going and licensing from Ray Charles the ability to use that sample in his song. So I think that practically speaking, if you weren't in the wild, wild west days where you're sampling old songs, nowadays I think what happens is usually they go and get the license directly from whoever they're trying to use it from.
Absolutely. And in fact, a good friend of mine is a high-powered music lawyer, and he's spoken to my copyrights class in the past. And I remember him telling the story of, I won't say which artist because I don't know if he would want me to publicize this, but anyway, a client of his had a very, very famous song and used a sample in it of a kind of traditional musician and a traditional musical work. And it's a sample of a recording, and never cleared the sample. And then what my friend said was, if you haven't cleared the sample and you release it commercially, don't even bother to go and try to find the sample owner and license it, because at that point they will find you. And at that point they can essentially name their price because you're already infringing.
Right.
And so that artist ended up having to give half, if I remember correctly, half of their royalties to the owner of that sample.
Wow.
Where they might have, and this was a huge, huge international hit. So they might have been able to get that sample, maybe pay $1,500 for a release to use that sample, just a one-time upfront payment to license that sample, but instead had to give up half of the royalties, which was going to be a lot more than it would have been to get permission to use the sample from the outset.
So do your due diligence. This is not a time to be begging for forgiveness. This is the time to go and ask for permission on the front end, unless you want to pay dearly.
Yeah, absolutely.
Well, I'm just going to go back over real briefly what we talked about today. So we started this conversation as copyrights part 2, but it turned into quite a bit about right of publicity. And we talked about, can you sue someone for posting a photo of you? Can you sue someone for posting a photo without your consent? Can I sue someone for using my photo? Can someone take your photo without your permission? What is protected when I record a song? Do I need to register my recording? Can I use a snippet of someone's song on my blog or my podcast? And can I cover someone else's music? And we talked about a lot of really interesting examples along the way. So, Professor Priest, thank you again for joining us. It's been illuminating. I really appreciate your knowledge. You know so much about this area of intellectual property that I think it really benefits everybody to hear from your wisdom and your expertise. So thank you for joining us.
Well, it's my pleasure. I'll be happy to do it again sometime.
Thank you very much. So until next time, for Professor Priest, this is Blaine Cluton, and I'm calling this session adjourned.